and around this courtroom. Madam Registrar, would you please call the case?
Good morning, Your Honors. This is case IT 0992T, the prosecutor versus Ratko Mladić.
Thank you, Madam Registrar. Today we'll hear submissions under Rule 98 bis. Rule 98 bis reads, at the close of the prosecutor's case, the trial chamber shall, by oral decision and after hearing the oral submissions of the parties, enter a judgment of acquittal on any count if there's no evidence capable of supporting a conviction. The defense has announced that it wishes to make submissions, oral submissions under Rule 98 bis, and has an opportunity to do so now. Mr. Mladić, it will be you who will make those submissions?
That is correct, Your Honor.
Then you may proceed, and I put hereby on the record that Mr. Stojanovic's co-counsel is present in court. Please proceed.
Thank you, Your Honor. Good morning, Your Honors. The duty falls upon me to present the Rule 98 bis arguments on behalf of the defense of General Ratko Mladić. At the outset, I want to clarify that nothing in our presentation today or in our choice of topics to be discussed should be interpreted in any way as a concession or admission of any part of the prosecution's case against General Mladić. Just because I may not address every part of the prosecution's case does not mean to imply that we believe the evidence they have presented on the same. In fact, we oppose and reject the prosecution's allegations and the case they have brought in total. Both General Mladić and his defense team look forward to presenting witnesses and evidence during the defense case to rebut each untruth and misinterpretation presented during the prosecution case. General Mladić believes in the truth and that we will be able to present that truth, and that once presented, it will demonstrate his innocence. While both he and the defense are mindful of and respect that during the war, regrettable events and even crimes occurred on all warring sides, causing losses, impacting those involved in and touched by the conflict. And our thoughts go out to all those aggrieved. We want to be clear. General Mladić never intended nor ordered any crimes, and at all times acted honorably to defend his country and to defend his people. Your Honors, your task at the 98 bis stage is to purge the indictment of allegations that are not supported by evidence upon which you could convict General Mladić. The defense's submissions are focused accordingly and will be divided into 4 substantive sections. First, I will address the interpretation and application of Rule 98 bis and advocate that a charge-based approach upholds the object and purpose of the provision. Secondly, I will assess the prosecution's evidence in relation to Jadar River, Shirokacha, and Schedule D of the indictment, destruction of religious sites, and demonstrate that the prosecution has not proffered any evidence capable of sustaining a conviction on these charges. Next, I will address third-party actors, and finally, genocide. Thus, the defense will respectfully invite your honors to duly acquit General Mladić of these allegations and allow the defense to focus its resources elsewhere. Rule 98 bis states that, quote, at the close of the prosecutor's case, the trial chamber shall, by oral decision, and after hearing the oral submissions of the parties, enter a judgment of acquittal on any count if there is no evidence capable of supporting a conviction. It is the use of the word count that has been latched onto by trial chambers to conclude that judgments for acquittals can only be entered in respect of entire counts and not individual charges. A textual interpretation of the rule has been utilized by trial chambers to confine itself to this when answering defense submissions requesting acquittals on individual charges within counts. The application of the rule turns on the interpretation of not only the text, but also the object and purpose of Rule 98 bis in the context of the trial as a whole. In Mladić, it was held that even though the statute is not a treaty, the rules of treaty interpretation contained in the Vienna Convention are relevant to determine its interpretation and application. This is the Mladić decision on defense motion on jurisdiction, 10 August 1995, paragraph 18. Although the tribunal judges do not always mention the Vienna Convention explicitly, the interpretive framework of the convention is used. The trial chamber in Mladić confirmed that by having recourse to the approach advocated in this framework, quote, the true purpose and intent of the statute and the rules of procedure and evidence are discovered, end quote. It noted that it is well settled that an interpretation of the articles of the statute and provisions of the rules should begin with resort to the general principles of interpretation codified in Article 31 of the Vienna Convention of the Law of Treaties and cited a multitude of cases that confirmed this. And this would be the Mladić trial judgment, paragraph 1161. Article 31(1) states that, quote, a treaty shall be interpreted in good faith, in accordance with the ordinary meaning to be given to the terms of the treaty in their context, in the light of its object and purpose, end quote. A textual interpretation, namely one of strict construction, limits the Chamber to determining whether a case is within the bounds of the intention of the statute and rule by the construction of the express language only. Following this, unless the defense is able to show that the prosecutor has failed to provide evidence capable of sustaining a conviction in relation to the entire count, then an acquittal will not be entered by the Chamber. However, as the Mladić trial chamber emphasized, the rule of strict construction is not violated by giving the expression its full meaning or the alternative meaning, which is more consonant with the legislative intent and best effectuates such intent. This encapsulates the dual-pronged interpretive approach advocated by the Vienna Convention. Article 31(1) of the Vienna Convention emphasizes that the textual and purposive approaches are not mutually exclusive interpretive methods, rather interdependent. The textual and the purposive approach are reliant on and responsible for the interpretation of each other. Thus, the word count in the 98 bis provision can and should be ascertained with recourse to the intention of the drafters and the purpose of the provision in the context of the trial as a whole, without violating the textual interpretation that the present jurisprudence is anchored to. Before the amendments to the rule in 2004, the provision expressly provided for a trial chamber to enter a judgment of acquittal where the chamber found insufficient evidence to sustain a conviction on challenged charges, a point which the Mladić trial chamber acknowledged the other month. The text read as follows, quote, an accused may file a motion for the entry of judgment of acquittal on one or more offenses charged in the indictment, end quote. Neither the word count or charge was used, rather that of offense. It is accepted that in the 2004 amendment, the word count was inserted into the statute, and that goes some way to implying that the drafters sought to restrict the application of 98 bis to counts as a whole. However, as the Dragomir Milosevic chamber highlighted, this interpretation has the potential to render the process, quote, virtually devoid of any practical application at the tribunal, end quote, as it fails to appreciate the multi-layered nature of the indictments and restricts itself to a purely domestic approach of the rule. That would be in the Dragomir Milosevic trial, 3rd May 2007, transcript pages 5641 through 5643. The purpose of the rule is twofold. Firstly, to remove any allegations that cannot be sustained at the earliest opportunity to ensure that the trial is expedited and that the defense's resources are not squandered. And secondly, to adhere to due process and acquit the accused of allegations that are not supported by evidence. This purpose does not change because the rule has been assumed from domestic law into international law. Rather, it should be applied in a manner that acknowledges the complexity of the indictment while adhering to its function at this stage in the proceedings. Anything that remains in the indictment requires the defense to call evidence and respond to the allegations, while the chamber must dedicate time to hearing and pronouncing on the evidence. It is simply a waste of precious resources and time to allow charges that do not have a real prospect of success by virtue of there being no evidence capable of supporting a conviction to remain in the indictment at this stage. Furthermore, the interests of justice do not limit themselves to victims' justice, but also to the rights of the accused. The tribunal's slogan may be bringing war criminals to justice and justice to victims, but the accused is innocent until proven guilty, and it follows that if guilt cannot be proved, then the accused must be acquitted. This is the premise of Rule 98 bis. The rule is a safety valve that protects the accused and the defense from unfounded allegations progressing and being the subject of the final judgment. If trial chambers take the count-based approach and restrict the application of Rule 98 bis, then the utility of this valve is lost, and with it the protection afforded to the accused that was deliberately incorporated from domestic law and written into the rules. The defense recognizes that there are many cases that have applied the count-based approach following the amendment on the basis of a textual interpretation of Rule 98 bis. However, just because the jurisprudence has moved in one direction does not mean that it is the one intended by the drafters that adheres to the object and purpose of the rule. It is the textual interpretation of the rule, not the rule itself, that has restricted it to a count-based approach. It is self-evident that the rule's function is to remove allegations from the indictment that, at the close of the prosecutor's case, are incapable of sustaining a conviction. The word offense in the pre-2004 98 bis provision was interpreted in the jurisprudence as encompassing both counts and charges precisely for this reason. The object and purpose of the rule did not change when the text was amended. Had the drafters used the word charge instead of count, trial chambers would undoubtedly have taken a purposive interpretation to the text to ensure that acquittals could be entered on entire counts, as this would conform to the object and purpose the rule seeks to achieve, notwithstanding the literal textual interpretation. The fact that the jurisprudence was deemed to be settled by the Mladić trial chamber does not redefine the object and purpose of the provision. That trial chambers have previously taken a textual interpretation does not mean that taking a purposive interpretation to the word count, so as to interpret it as including the possibility of an acquittal on individual charges within a count, is not tantamount to judicial law making. This approach is not gap filling, nor is it exceeding the competence of the trial chamber. Rather, it is giving effect to the object and purpose of Rule 98 bis in accordance with the rules of interpretation outlined in the Vienna Convention. Should your honors conclude that the parameters of the rule remain ambiguous, even after it has been interpreted in light of its text and the object and purpose of the provision, then the defense submits that the interpretation most favorable to the accused should be followed. To this end, your honors are urged to have due regard for the principle of in dubio pro reo. The appeals chamber in Mladić deferred to this when assessing the ambit of the provisions in the statute and the rules, and emphasized that, quote, any doubt should be resolved in accordance with the principle in dubio pro reo. This is the decision on appellant's motion for extension of time and admission of additional evidence of 15 October 1998, paragraph 73. Therefore, to take a textual interpretation alone is to create a judicial bulwark against acquittals on individual charges, which is a consequence that is self-evident from the jurisprudence. Not only does this offend the object and purpose of Rule 98 bis, but also the principle of in dubio pro reo, as any doubt as to the ambit of the provision should accord to an interpretation that favors the accused. In relation to the rule, the defense submits interpretation that favors the accused is the one that allows the ambit of the rule to provide for acquittals on individual charges as distinct from the count as a whole. Your honors, the count-based approach is one that shrouds individual charges in a legal veil that prevents them from being separated from the count as a whole, and as such, the defense from challenging charges that are not substantiated by evidence. The imposition of a legal veil is not dissimilar to that taken in corporate law, where companies are treated as independent legal entities to prevent litigants from going behind it and recovering from the individuals within it. The corporate veil cloaks the individual and prevents them from being challenged separately in the same way that the count-based approach prevents individual charges from being addressed in isolation of the purposes of 98 bis. What the defense is advocating is not that this veil be lifted entirely, but that the chamber, on a case-by-case basis, determine whether there are circumstances that justify the piercing of this veil in accordance with the object and purpose of the provision. To take a blanket approach and reject every challenge made by the defense to individual charges is not only would not only offend the object and purpose of Rule 98 bis, but allows the prosecution to hide individual charges behind a veil that makes all the charges in a count infallible, even if there is no evidence capable of supporting the conviction. It is for this reason that there are exceptions to the presumption of the inviolability of the corporate veil, to prevent individuals from exploiting the veil to remain outside the reach of the law. The defense implores the Chamber to acknowledge that exceptions to the count-based approach are essential to uphold the object and purpose of Rule 98 bis. Having a presumption against acquitting the accused of individual charges within a count is one thing, but to remove any opportunity for this to occur goes beyond what is necessary to prevent the danger of an incident-based or piecemeal application of Rule 98 bis.
Interpreters note, could the speaker kindly slow down? Thank you.
A blanket approach by the Chamber offends the fundamental aspect of the rule's purpose: to give effect to and ensure the accused is tried expeditiously, and to uphold the requirements of due process, and allows the prosecution to exploit the count-based approach to disguise the evidentiary defects in their individual allegations, to adjudge and declare that the count-based approach should be applied to the present case in accordance with the jurisprudence is to confirm that 98 bis is nothing more than a paper tiger, devoid of any practical application for the defense by virtue of the fact that trial chambers apply an overly restrictive interpretation of it. Furthermore, we have seen from the medical records proffered in conjunction with this trial chamber's order made pursuant to Rule 74 bis that ensuring that the trial is not unduly prolonged is of paramount importance given General Mladić's health. The latest consolidated report of Drs. Hollander and Dr. Cross noted that delaying or protracting the course of the trial would be disadvantageous to General Mladić because of advancing age. Your Honors, maintaining charges that have no prospect of success extends the conclusion of the trial and increases the strain on General Mladić unnecessarily. If there is no evidence capable of supporting a conviction at this stage, then it follows that the Chamber has a responsibility to the accused to ensure that he is tried expeditiously, particularly in the present circumstances where General Mladić's health is a pivotal concern. Turning to the defense's submissions in relation to specific charges, we recall that Your Honors are both the triers of law and fact, and that issues pertaining to the reliability and credibility of the witnesses are not normally dealt with under Rule 98 bis. However, the trial chamber in Mladić and Cherkez emphasized that there is one situation in which the chamber is obliged to consider such matters. It is where the prosecution's case has completely broken down, either in its own presentation or as a result of such fundamental questions being raised through cross-examination as to the reliability and credibility of witnesses, that the prosecution is left without a case. This is the 6 April 2000 decision on defense motions for judgment of acquittal, paragraph 28. This represents an exception that draws a distinction between merely weak evidence and that which would render a conviction unsafe if the chamber were to rely upon it as affirmative evidence of guilt. In this case, the defense submits that the prosecutor's case in relation to the incidents at Yadar River and Shirakocha, issues pertaining to the reliability and credibility of witnesses have left the prosecutor without a case. In relation to Schedule D of the indictment, destruction of religious sites, the defense asserts that the evidence presented is so incapable of belief that the prosecution is once again left without a case. Turning first to the Yadar River. Following the case advanced on count 2, the evidence tendered in relation to the indictment at the Yadar River, which is Schedule E 1.1 of the indictment, taken at its highest, cannot support the conclusion that these deaths were the start of the organized summary executions of prisoners by gunshots in the hands of the VRS, let alone acting under orders of General Mladić. The prosecutor alleges in the indictment that 15 Bosnian men were executed on the bank of the Yadar River as part of an organized killing within Srebrenica. As the defense will show, the prosecutor's evidence does not support criminal liability on the part of General Mladić, as the only witness's evidence that attests to the prosecutor's case collapsed under cross-examination. The prosecution have relied on the witness testimony of protected witness RM 314, who is held out by the prosecution to be a survivor of the massacre, to prove not only did the executions occur, but that the VRS was responsible for the executions. While the prosecution cited 6 witnesses in the pretrial brief to support this incident, only RM 314 provided evidence of the events that occurred at Yadar River and provided oral testimony on the 8th and 9th of May 2013. The prosecutor's case relies solely on RM 314 being a survivor of this event and thus an eyewitness that can attest to the ethnicity of the other prisoners, the identity of the perpetrators, and the manner in which the prisoners were executed. However, when subject to cross-examination by the defense, it became apparent that his account was inconsistent, was contradicted by documentary evidence, and as such, his testimony was incapable of belief. RM 314's evidence collapsed under cross-examination in key areas and is so unreliable that the prosecution has failed to provide any evidence capable of supporting a conviction. RM 314's oral testimony, firstly, raised doubts as to whether his injuries were sustained and as a result of an attempted execution at the Yadar River, and thus whether he was actually present at the time. Secondly, undermined the reliability of his identification of someone who was alleged to be a VRS shooter at the incident, and finally proved inconsistent on the issue of his status as a civilian at the material point in time. The witness claimed in his written statements given to the Office of the Prosecutor and under oath that he sustained gunshot wounds on the River Yadar as the result of an unsuccessful execution attempt by members of the VRS. He stated that a bullet entered his hip as a result of a gunshot wound, which entered from the right side to the left, with the left side of his body being where he sustained the injury. This is at the trial record transcript pages 10,861 through 10,862. He describes in his statement that he floated in the river to escape. Despite RM 314's account of the severity of his injuries, he conceded in his statement that the medical personnel at Tuzla did not consider his wounds to be serious. This is P1435, page 7. Additionally, the medical examination conducted on the Free Bosnian Muslim territory concluded on 16th July 1995 concluded that his injuries were sustained as a result of an explosive injury, which is evidenced at transcript page 10,899 and also Exhibit D 282, and therefore not a gunshot wound, as he stated in his statement and under oath. This diagnosis was proffered by the medical staff that attended to his injuries. And the documents contain their expert medical opinion on the cause. That the medical experts who examined and treated RM-314 came to this conclusion undermines his account that he was shot at, thereby compromising the prosecution's case that RM-314 was injured as a result of an attempted summary execution at the Yadar River. As the medical evidence is inconsistent with RM-314's account of being a survivor of the executions, substantial doubt has been raised as to whether he was even there at the time the incident occurred. RM-314 revealed that he had provided a statement about how he sustained his injuries to a man that told him he worked with journalists and was wearing a black t-shirt with BH Army insignia. This is at transcript page 10,879. After questions from Judge Fluge, RM-314 stated that it was because he was forced to do so by the security officer of the infirmary that wore the BH Army insignia. However, no evidence of physical coercion was provided to confirm this account, nor did RM-314 provide any statements to the prosecution about this allegation prior to his testimony.
May I interrupt, Mr.
Yes.
Lukic? When you say he was forced to do so, to do what?
Forced to give a different account of how he had been shot in the prior statement, Your Honors.
Since you're interrupted anyhow, Mr. Ivity, to this moment, you referred to D282 as confirming that the injuries were sustained as a result of an explosive injury.
That's correct.
I am just wondering where exactly to find that in this document.
That should be the medical records, the Latin diagnosis of the wound or of the injuries contains, I believe, the Latin term explosivus.
Let me just have a look, because in English translation it says several times illegible, but perhaps the original then could.
I believe it's in the original and it's in Latin. I could have that checked at the break, Your Honors. And
I'll check it right away whether the Latin gives us any. Please proceed.
thank you.
Just a further clarification. You said he was forced to give a different account of how he was shot. Is it how he was shot or how he was injured? Your contention is that he was not shot.
That is correct. Injured is what I would say then. I don't remember what the witness actually said in the transcript section.
Could you ascertain that?
Could
you ascertain what he said?
At this point, I cannot.
Later.
Later, yes. At transcript page 10,880 through 10,882, after questions from Judge Fluge, it transpired that in the handwritten statement he gave to the journalists and signed to confirm the truthfulness of was in fact false testimony, as conceded by RM-314. When pressed as to why he had written that he was shot in Karakai, RM-314 stated that it was because he was forced to do so by the security officer of the infirmary that wore the BH Army insignia. Further, RM314 also conceded at transcript page 10,887 that his statement submitted in Popovich, which detailed RM314's account of the incident at Yadar River, is riddled with mistakes, despite signing it to confirm its truth and accuracy. The defense again notes that RM314 is the only witness that can attest to the events that occurred, and he has shown a propensity for providing untruthful and inaccurate testimony, which, in conjunction with the inconsistencies between his recollection of the events that occurred and contradictory medical evidence, discredits the prosecutor's case and renders his evidence incapable of supporting a conviction. Significantly, doubt raised as to his presence at the Yadar River also impacts on his identification of a certain individual perpetrator whose identity was provided in closed session. And in an amended statement in 1999, after being triggered by a vague description made by a third party in 1995. You can find this at transcript page 10,901. As RM314's description of the perpetrators was originally limited to them being dressed in camouflage, but without any insignia being identified, this identification is the only connection the prosecution has to link members of the VRS with the commission of these executions. And I urge your honors to look at transcript page 10,889 through lines 1 through 11. The prosecution noted during the proofing of RM314 that the witness was asked about why he failed to mention this individual in his earlier interviews and statements. The witness indicated that he was not completely sure of his identity at the execution site until well after the events, based upon information he received both at the time he was held captive and thereafter, which is detailed at transcript page 10,914. The witness confirmed his previous testimony in Popovich, which revealed further inconsistencies about the witness's recollection of this person's height, of this person's hair type. That's at transcript page 10,915 through 10,916. It is significant that in this testimony he stated that he knew this individual, alleged to be a perpetrator, well. But despite this, RM314 was unable to identify him at the material time or even provide an accurate nor consistent description of him. In the absence of this identification evidence, there is nothing to suggest that the VRS was responsible for the shootings, as RM314 states only that the men responsible wore camouflage. Taken at its highest, RM314's identification does not come up to proof as it is not only so incapable of belief that he would not remember someone he knows being there, but also that this evidence only came to mind 4 years after the incident, after hearsay triggered RM 314's memory. Both the prosecution and RM 314 rely on his civilian status at the material times to confirm the illegality of the acts that occurred on the Yadar River. RM 314's status is relevant in two ways. Firstly, to the prosecution's case that Bosnian Muslim civilians were unlawfully killed, and secondly, that they were targeted because of their ethnicity, as opposed to them posing a military threat as soldiers. The medical document dated the 16th of July, 1995, D282, from one of RM 314's medical examinations, lists his profession as being a soldier and performed messenger or courier duties at the Srebrenica PS. The abbreviation OS Srebrenica was used on the document and is taken to stand for the Armed Forces Srebrenica, which RM 314 agreed to. That's transcript page 10,896, lines 12 through 22. After receiving medical attention, an official document signed by the medical staff states that he was a part of a military unit, and after being discharged from the medical institution, the patient should immediately report to the doctor attached to his military unit, thereby suggesting that the infirmary held the opinion that he was a soldier. You can find this at transcript page 10,900 to 10,901. Despite evidence to the contrary, RM 314 insisted he was a courier for the civilian protection. This is transcript page 10,896. Yet conceded that he failed to correct the infirmary. Although he states that he was simply a courier, when RM 314 surrendered, he was found with a standard hand grenade in his possession, the same used by the arsenal of the former JNA with which he served. This is at transcript page 10,905, lines 16 through 20. His explanation that he was given it by an acquaintance, not provided with instructions, and had no experience of using, is dubious, particularly in light of the fact that he conceded that he served with the JNA, and the medical evidence suggesting that he was in fact a soldier at the material times. This provides a more believable explanation as to why he was armed with JNA weaponry and in the absence of instructions for its use. The fact that RM 314's evidence is so inconsistent on the point undermines not only his reliability and credibility in relation to this, but also in relation to the overall statement. RM 314 was the sole witness that supports the prosecution's case in relation to the Yadar River incident, and his evidence does not come to proof. Taken together, the witness's propensity for providing false statements, failure to correct inaccurate statements until pressured under cross-examination, and the existence of official medical evidence that contradicts his case demonstrates that his evidence is incapable of belief. There has been no forensic evidence recovered from the site of the alleged shooting which would support the story of RM-314, despite the efforts of the prosecution investigators. Thus, the prosecutor is left without a case, and an acquittal should be entered. As such, the defense requests that the Yadar River incident be stricken from the indictment to preserve judicial economy and the defense resources. Turning now to Shirokacha.
Mr. Mladić, I'm looking at the clock. We would have a break in approximately 3 minutes. Would it be?
We can have it now, Your Honor.
Yes. And before we take the break, perhaps I noticed that on D282, where quite some critical questions were asked to the witness, that nevertheless the English translation still, especially on the vital points, states that it was all illegible. If the defense and prosecution could try to seek an agreement on what was legible, especially where the explosive wound is mentioned, because I see the word explosiva on the original where it does not appear on the English translation, that certainly would assist the chamber in enabling it to better understand the argument made. So if that could be resolved, that would be appreciated. We take a break and we will resume at 10 minutes to 11 o'clock.
All rise. We will be back.